I'm going to transition from a structural engineer to a legal framework. So, Allie, you can't say this is going from the sublime to the ridiculous. So, the framework the analytical framework I want to do for doing that is to take you through what lawyers do every day, which is to understand what the risks of liability, for example, to a property owner are. Lawyers read the cases that have been decided by the appellate courts of this state and of other states. And so, in order to do that, these cases tell the story of one incident that's happened, sometimes more, but usually one incident, and then apply the rules of law to that incident to tell you what, or if at all, what liability the owner has in these types of circumstances. So to do that, I want to take you back, all the way back to December 22nd, 2003. I want you to think you're here in Paso, Robles. It's in the morning. It's 10:59 in the morning. I think you probably know what's going to happen at 11 o'clock. But place yourself here in Paso, Robles at 10:59 in the morning. The building that you're looking at is the Acorn building in downtown Paso Robles. This is a downtown area that has many of the kinds of buildings that Ken was talking about, and had all the concerns for unreinforced masonry and all the dangers, and had an active city council that had enacted an ordinance along the lines that Ken has talked about. And I'll come back to the specifics of that in a second. At this moment, right before 11 o'clock, anyone who was a building owner still had the ability to engage a structural engineer, an architect, someone to help them plan for a way to mitigate the harm that would occur to other people. I'm going to focus on the potential damage to third parties as opposed to your own property, your own building, your own asset. The damage that the building might cause to other people at this time. You still were looking forward compared to looking backwards the way a court looks when a court decides the issue of liability. So at 10:59, there was a dress shop on the second floor of this building, and there was a 20-year-old woman by the name of Jennifer Lynn Myrick who was working at that shop, along with a 50-year-old woman by the name of Marilyn Frost Zafuto. Ms. Zafuto was very happy. She'd gone back to work because her daughter had just entered college, and she wanted to be out and helping everyone in the community, and she loved the interaction she had with people. Jennifer Lynn Myrick was 20 and was planning to get married. So at 10:59, they were working in the shop. 11 o'clock happens, and the San Simeon earthquake hits. Now, at this point, Paso Robles is one of the least well-prepared areas for an earthquake that's a serious seismic event. These are some of the statistics you see for that earthquake. In downtown, the Acorn building especially was in jeopardy because it had not yet been retrofitted. In other words, they had sought the help and sought the advice of people such as Ken, but had not yet implemented any of the measures that had been advised to make the building safer and to protect the safety of the people within the building and the people nearby. So, what happened? The earthquake hits, and the building structure begins to move, and these two women I just mentioned begin to exit the building. And as they're exiting the building collapses, and the two women are crushed. And the way that and both died, tragically. The way that this gets described, and the way that owners ultimately have to face what happens after this, is in the text written by the Court of Appeal. And so I'm going to take you through the text written by the court and have you do what lawyers do every day, which is just to read through these opinions and to see how the court reasons, what the defenses of the owner are, and what the court believes could or should have been done. So the court, of course, begins by reciting the situation that I just mentioned. And I've highlighted a couple of the passages. Now, here's the history. And again, this is one specific instance of what Ken was just talking about. So the city itself had retained a consultant. The city had developed an ordinance. And the city had given notice to building owners within the city that work needed to be done to make these buildings safe for the public. The city, as you see in the last line, sent notice to the building owners. And they did that in December of 1989. But as part of the program, the city eventually extended the date by which owners had to comply with the ordinance all the way to 2018. So if you complied on December 31st, 2018, you would have been in compliance with the ordinance. So you can easily imagine what the defense of the owner would be. And that is that the owner had retained a structural engineer. The owner had gotten a plan for reinforcing the building and making it coming up to the standard of the ordinance. That the city had made the judgment of when it was necessary to comply with the ordinance. So the city had made the assessment of when it was reasonable to do the work, and the owner said, I had until December 31st, 2018 to do that work. And so the question is not just what you saw with Ken's slide on complying versus actually solving the problem, but what work needed to be done in order to protect the public. And is compliance with the owner, in other words, if you're a building owner, if you're working with building owners, as almost all of us here do, and that's why we're here, a building owner has to understand the answer to the question, is complying with the ordinance going to be a sufficient defense if a lawsuit gets filed as a result of catastrophic damage due to a seismic event? So in the particular case in Paso Robles, the work had not begun. Probably one of the worst facts in the case was that the owner had been able to do other work. The owner had been able to install an elevator. So by installing the elevator, the owner showed that they had a budget to do some work, but they chose to do other work rather than do the work that would protect the public. And so the court began analyzing this issue and analyzing the facts with the simple question. It's the basic rule of liability. It governs us. Every day, everything we do. If I were to take this mouse and throw it out at you, assuming my aim was good enough to hit someone, the question would be, do I have a duty not to do that? Well, obviously you do, because you have a general duty to avoid doing those acts which would cause harm to other people. So I can't just throw something from here into a group of people, because that is very likely to cause harm. So take that and extrapolate that to the position of a building owner. What does a building owner know? A building owner knows that it is highly likely that at some point in the next 35 years, there will be a catastrophic seismic event that can threaten the structure of the building owned by the business. If you know that, the question then is, knowing that, what do you know about your building? How safe is your building? If your building is not safe and you know it, but you know you have several more years to comply, then the question is, are you reasonable? Did the owner act reasonably in deferring compliance with the ordinance out to the date that the city was requiring for compliance? So that's the test that's going to be applied ultimately by the court. And so the owner is responding, no, the city told me when I needed to comply, so I'm okay. I'm within the time period. That time period hasn't come up yet. And you can see here exactly how the court dealt with that. That the court doesn't look favorably on the use of statutory compliance as a defense to tort liability. In other words, what did the owner know? When did the owner know? What could the owner do? What did the owner have the budget to do? And what did the owner do otherwise rather than take the steps necessary to protect the building? So that question is not a question that gets debated amongst us. This question gets decided by the jury. So a jury will be the group that answers this question. And now you can imagine the filter that this question is coming through is not through an analytical report that Ken prepared. The framework for that analysis is the lives of two people who are no longer with us, and that's the framework through which the issue of liability will be assessed at the trial level. It's only at the Court of Appeal level where the Court of Appeal is deciding whether to affirm or whether to overrule something that happened and set aside what happened at the trial court level. At the Court of Appeal level, it's a dry analysis. But at the trial court level, where these rules are applied, the analysis is through the real-life human story that you saw that the appellate court started out their recitation of the case about. So what does you see the claim, the owner makes the claim, they're in compliance, and that the reasonableness of what they did you take reasonable steps to protect the public? The reasonableness is determined by the jury, but the question is, can the owner argue that the city, by adopting an ordinance and setting a date for compliance, did the city make that determination for you? And the answer to that question is no. The answer to the question is, did you know enough and did you do enough to protect not your building, not your assets? Did you do enough to protect the public? And the rule to take from this opinion is, what I've highlighted on this page is the overriding policy, this test of reasonableness. What can you do, based on what you know and based on what resources you had available? The overriding policy is to protect public safety. So that's the legal framework that these questions come up in. That's the question that a jury will be answering if have the unfortunate effect of being exactly in the position. If Ridgecrest had been southwest by 135 miles, right in the middle of downtown Los Angeles, think how different. Obviously, none of us would be here meeting today, but if that had happened, think of the discussion that we would be having about what each building owner could have done that they failed to do. Because now we're looking back in hindsight. We're at a point today, you're here, you're taking a step to help protect a building owner, whether it's you or whether it's a colleague you work with, whether it's someone you consult with. You're taking a step to learn something about the problem, the issue. How do I address this issue? As opposed to burying your head in the sand, which is the only thing that for sure doesn't work. And now that you know this, you know the experts that are available, the consultants that are available, the work that's available, and the likelihood that something will happen. You have the tools to begin addressing this problem. Do you have to complete it? No. You have to do what's reasonable. And a jury may decide that something less than completing all the work is reasonable. But what you have to do is to recognize the issue based on what you know and do something. And so that's what the jury decides. In looking back in this sort of paradigm of reasonableness, what do you know? What would a reasonable person know? A reasonable person would know we are going to have at some time in the future a catastrophic, big seismic event. What have you done to find out what you could do to protect the public against that? And what else? What did you do? And what else could you have done? And so that's the framework in which this gets decided. So that moves from sort of the analytical framework that we all have, all these fabulous tools and experts that we all have available, to what this will look like in hindsight if we have to look backwards at the time. So, Adriana, thank you. And